More than 1 year after the January 6th Capitol riot, debate continues over the rulings on insurrection cases and the overall fate of the Supreme Court. Supreme Court Justice Clarence Thomas is facing pressure to recuse himself from these cases after his wife, Ginni Thomas, sent multiple incriminating texts to then White House Chief of Staff Mark Meadows. These messages urged Meadows to work to overturn the results of the 2020 presidential election, and they've led many to question Clarence Thomas's knowledge and neutrality in this matter.
Did Thomas know about his wife's activities? What is the extent of their cooperation?
Does this point to larger systemic issues facing the Supreme Court, and is it time for reform? I'm Valerie Wencis.
And I'm Stephannie Joseph, here to tackle all this and much more right now
on That Point.
The Supreme Court's disapproval rating has reached 44%, a significant increase from 29% in August 2020, according to a Pew Research poll. Debate over reform rages throughout political spheres across America, with proponents of reform offering term limits or additional seats on the bench as possible remedies.
The judicial branch is gaining federal importance as tensions between the president and federal legislators often result in gridlock. The court, which was designed to play referee, has the ability to create laws through their jurisprudence, which may further politicize the role of the justices.
Justice Clarence Thomas has recently been at the center of Supreme Court criticism due to his wife's role as a Washington lobbyist and her involvement in the Capitol riots. This has many critics and supporters questioning the self-policed ethics of federal judges.
A leaked draft opinion by the conservative justices released by Politico on May 2nd shows a plan to overturn landmark reproductive freedom decisions Roe v. Wade and Planned Parenthood v. Casey. The conservative-leaning justices hold a 6-3 supermajority in the Supreme Court since the confirmation of Justice Coney Barrett, which has many Democrats calling for change. Stephannie sat down with Bloomberg Supreme Court reporter Kimberly Robinson to navigate suggested reforms.
Public disapproval of the Supreme Court is up from 33% in 2020 to 44% this year. That's according to a February Pew Research survey. As opposition to the court grows, many are asking what Capitol Hill should do to regain public confidence in it. I'm joined by Bloomberg Supreme Court reporter Kimberly Robinson to help us navigate and delve deeper into suggested reforms for the court. Hi, Ms. Robinson. Thank you for joining us.
Thanks for having me on.
Of course. So to start off, how have members of the Supreme Court tried to restore public trust in its legitimacy and objectivity over time?
Well, packing the courts, adding seats onto the bench is not something new. It's actually part of the lore of the Supreme Court is this switch in time that saved 9, a reference back to, President Roosevelt and his quest to kind of add more justices onto the court that was ruling against him. So, over time, we see that the justices have had to grapple with these kinds of issues. I would say, as for what the justices themselves are doing, they're trying to, do law, do what it is that the American people expect them to do. But I think that, the recent abortion case that we may talk a little bit more about tonight really highlights how the justices all kind of agree that they should be working to strengthen the institution, but they just don't agree how to do it.
And I really feel like this isn't the first time that there have been calls for reformation. So what about these calls now is different from the past?
I think really the voices, that there are so many voices coming together to suggest these reforms is something that's different. And so we saw this was even an issue in the 2020 presidential election, that the candidates weighed in on the importance of how many justices do we have on the court? Should they have term limits or should they be there for life? And so I think it's just a matter of, these are not new things that we're hearing, but we're hearing them a lot louder now.
So what about this moment in time makes maintaining this trust in the court crucial?
Well, I think, we've seen so much partisan divide in the other branches of government. You look over at Congress and it's hard to watch, a hearing there without, just kind of culture wars and, partisan talking points coming up just at every issue. And I think right now the Supreme Court is starting to get snarled in that. And we see it most obviously with the Supreme Court confirmation hearings that we just saw one recently. You can really see that a lot of the questions that were asked of the nominee were not about, law and how she would interpret the Constitution, but were instead, on partisan talking points about, child pornography and, things like that. So I think that's why it's really critical now that this issue is coming up.
Definitely, and I know, especially during those confirmation hearings, that there were renewed calls about an ethical code of conduct. So what would it take to implement and enforce that ethical code of conduct for the court?
Well, that's a really good question, and I think it's not one that really has a clear answer. So the Supreme Court says that it doesn't have an ethics set of rules that it's bound by, but that it does consult other ethics rules that bind lower court judges. And, the reasoning that they're thinking is that they're a co-equal branch of government. So it's not as if Congress can force them to do anything. They like to say, well, how would you like it if we told you, Congress, what you had to do too? It's more of a hands-off approach. And so we're kind of just taking them at their word that they're consulting these, ethical rules. I think another big problem for the Supreme Court is who polices the Supreme Court? If the justices break those ethical rules that they say they're following, there's not really anybody who can enforce it. So again, we're kind of stuck up to their good nature to follow these rules.
And I know that we had mentioned earlier those term limits and rotating justices. So if we go back to President Biden's Supreme Court Commission, they had said that there is, quote, profound disagreement over whether the court should be expanded. Is court expansion something easier said than done?
Well, actually, court expansion is probably one of the most controversial measures, but it's actually the one that's the easiest to get done. And that's because it's really just left up to statute. Right now, federal law says there's going to be 9 justices. That law has been changed many times, not recently, but it's really just a matter of getting both houses of Congress on board and then a signature by the president.
And so what about term limits as an alternative? What would be the potential benefits and drawbacks of that?
Well, we see term limits is probably one of the reforms that have been before that has the most agreement on one that they could reasonably take. And we've seen outgoing Justice Stephen Breyer comment on how he thinks term limits could be good. And I think the idea of term limits is really trying to bring down the temperature with these Supreme Court confirmations. The idea being that if you have 18-year terms, every individual nomination isn't going to be such a big deal. It's not going to carry the same weight as what we have now, which is a lifetime appointment. Justices who are going to be on the bench and making law for a generation. And so the whole idea is really just to calm things down in Washington and not have the justices, on their kind of first introduction to the public be put in the middle of this political spotlight.
And so it's been a year since the commission's report has come out. What, if anything, has Congress or President Biden done with it?
It doesn't seem like they've done anything with it. Notably, the report did not actually make any recommendations as to whether or not they should go ahead and impose these reforms on the Supreme Court. And everybody's just kind of waiting to hear whether or not there will be some kind of comprehensive measure. But that doesn't mean that things aren't going on in Congress. Even before this report, we saw Congress really pressing on ethics for lower court judges. There's been a lot of movement around Me Too and how that affects people who work in the court system because they aren't subject to the same laws that Congress and the rest of the country are. And so we do see those kinds of measures moving through Congress, though nothing seems to get beyond an introduction. We haven't really seen a vote on any of those measures yet.
And I know that there's been another alternative suggested. We've talked about before how no one polices the Supreme Court. Well, when it comes to recusal, the same thing applies. I know that has been a recent conversation with Justice Clarence Thomas and his wife's connection to the January 6th insurrection. So do you think it's likely that any reformatory action against Justice Clarence Thomas will occur on the Supreme Court?
Well, the Supreme Court has said time and time again that it's really up to each individual justice to recuse, and, they're going to keep their hands off. So I don't foresee there being any real measures, put on to Justice Clarence Thomas unless he decides he wants to recuse. And I think the reason for that is that the Supreme Court thinks that recusals in the highest court in the country are just different than recusals in the lower court. In the lower courts, you can go around and find another judge to replace that person. But in the Supreme Court, you can't. And so you're stuck with the possibility that you could have an evenly split court that can't make decisions. And that's a situation that they just don't want. So, for Justice Clarence Thomas, it's up to him and his chambers to figure out what he's going to do next. And the only real recourse politically is an impeachment, which at this point it has really historically never happened.
Right. Well, only time will tell, and we'll definitely keep our eyes out and see what happens. So thank you so much for your time today.
No, thanks for having me on.
Ginni Thomas, Republican lobbyist and wife of Supreme Court Justice Clarence Thomas, has come under fire for her involvement in the January 6th Capitol riots, resulting in calls for Justice Thomas's recusal from upcoming related cases. Ginni's outspoken conspiratorial beliefs and history of influence within the Trump administration has garnered criticism in the past. According to a CNN report, sources within the Trump administration worried that Ginni had exploited her husband's position to gain access to the former president to influence future legislation while spreading political misinformation. Now she faces investigation by the January 6th Select Committee for her newly uncovered support of the protests. In March of this year, the Washington Post obtained 29 text messages between Ginni Thomas and former Trump Chief of Staff Mark Meadows. In these leaked messages, Ginni endorsed the actions of the insurrectionists, saying, quote, "The left is attempting the greatest heist of our history." While Ginni has since condemned the violent acts of the group in a Free Beacon interview, she has continued to support and defend their efforts. As the House January 6th committee continues to gather evidence before consulting the court, many have called for Justice Thomas to withdraw from cases in which he or his family have substantial financial interest. Ginni has a public history of involvement in the Stop the Steal movement and collects income from organizations such as Liberty Consulting. The couple have claimed they have never overstepped any ethical guidelines. They even refuse to discuss cases with each other until a decision has been made. Ginni's actions on January 6th have experts wondering if Justice Thomas could ever reach a fair decision. Back to Stephannie and Valerie at the desk.
Thank you, Nico. The Congressional January 6th Commission is getting ready for live hearings this summer. One of the people they hope to call is Ginni Thomas, the wife of Supreme Court Justice Clarence Thomas. Many Democrats are calling for Justice Thomas to recuse himself from January 6th related cases and have called on Congress to set up a judicial code of ethics for the High Court. Valerie sat down with constitutional law experts Kermit Roosevelt and Ilya Shapiro to discuss these issues.
We're talking today about the issue of whether Supreme Court Justice Clarence Thomas should recuse himself from cases relating to the January 6th Capitol riots in light of his wife's push to overturn the 2020 election. Now joining us are two constitutional law experts, Ilya Shapiro, formerly of the Cato Institute and author of the 2020 book Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, and Kermit Roosevelt of University of Pennsylvania's Carey School of Law, and author of newly released book, The Nation That Never Was. Gentlemen, thank you so much for joining me today. So let's just cut to the chase. Should Clarence Thomas recuse himself? Professor Roosevelt, why don't we start with you?
Well, I think he should. Judges or justices are supposed to recuse themselves from cases in which their impartiality might reasonably be questioned. So they're supposed to avoid not just actual conflicts, but the appearance of conflict. And the statute that I was referring to there goes on to say if your spouse has an interest in the proceeding, you should recuse yourself. And it seems to me it's pretty clear that Ginni Thomas has an interest that's sufficiently close to this proceeding that Justice Thomas should not have been hearing cases about it.
Okay, and Ilya Shapiro, what do you have to say about that?
I completely disagree with that. Ginni Thomas is not a lawyer for President Trump or was not part of the administration. is not part of any group that was involved in the relevant litigation as either a party, a lawyer, even an amicus. And so, whether it's appropriate for the wife of a justice to be a political activist is a completely separate question. The question here is whether the justice should be recused because of an appearance of some sort of conflict. And I don't think, especially in this day and age, that we attribute a spouse's activity to the other spouse. And so I think this is well within the lines of other things that in the past that both justices and lower court judges have not recused regarding.
So, Professor Roosevelt, how would you respond to that? And are there instances when a justice really couldn't be aware, and how do you respond?
Well, there's one point that Ilya made that I think is a good point, which is we're not imputing a spouse's activity to the justice. So no one is saying, I believe, or if they are saying they're mistaken, that Justice Thomas should recuse himself because he's effectively a participant in the attempt to overthrow the government, right? We're not attributing the acts to him. The question is he married to someone who has an interest in the proceeding or who is involved in the events that give rise to the proceeding? And I think it's pretty clear that she was. It's a question of degree. She's not, as Ilya said, a lawyer for President Trump. And her texts were not the ones that were going to be turned over, so it's not a direct connection. But I think that reasonable people would say she was sufficiently involved in the underlying events here that his impartiality could reasonably be questioned. And that's the test.
I don't know about reasonable people. I think the only people pushing for his recusal here are left-wing activists and pundits. And so it's not surprising that they would want Justice Thomas off any case.
Well, I would disagree with that. I think it's people who care about the Supreme Court, who care about the legitimacy of the Supreme Court, who are pushing for this, because this is a self-inflicted wound by the Supreme Court, which makes it look more and more partisan.
So what's at stake here? What's at stake if he doesn't recuse himself?
Well, I don't think very much is at stake in concrete terms, in terms of the outcome of the case, because what we've seen so far is it was 8-1, right? Justice Thomas seems to be an outlier on this. So he's not going to be casting the deciding vote. But what is at stake is the legitimacy of the Supreme Court. And, there's momentum now for Supreme Court reform. I was actually on the Supreme Court Reform Commission. I think there are changes that should be made. But I think that anyone who cares about the court as an institution should be concerned about activities by the justices that increase the perception that the court is just a set of partisan actors. And a refusal to recuse in a highly charged partisan issue where one's spouse has direct involvement in the underlying events, I think it definitely hurts the legitimacy of the court. And ultimately, that's what's at stake.
And Ilya Shapiro, do you have any follow-up comment?
Yeah, Professor Roosevelt said that one thing he said was the justices' activities, and that's exactly what the focus on needs to be here. I don't think anyone reasonably says that his vote in that particular case, where he was the sole dissent, is a deviation from his normal views on executive power and executive privilege. That would be unexpected. So I don't think anyone can say that he was tainted or did something unexpected because of this potential or so-called apparent conflict. And I don't think it would be in the future. And it seems like the only people questioning the legitimacy of him here are those of the type on the left who question the legitimacy of all of the Republican-appointed justices for various reasons, ranging from the blockade of Merrick Garland, making Neil Gorsuch illegitimate, the rushing through of Amy Coney Barrett's confirmation, making her illegitimate, Kavanaugh and the absurd allegations of serial gang rape, Roberts and Alito, because of course they were appointed by Bush, who was selected by the court, not elected, so-called, and then Thomas himself because of the sexual harassment going back. It's this is the folks who are shedding crocodile tears over issues of legitimacy are those who themselves argue about the lack of legitimacy whenever there are decisions or justices appointed whom they don't like.
Professor Roosevelt, you were shaking your head a little bit. Any follow-up there, or should we move to the next?
Well, I was listening to Ilya, and he actually made a quite persuasive case against some of the justices. I was a little surprised to hear that coming from him. He almost won me over. I don't think of myself as a radical, and I believe elections have consequences. I think that we have a broken nomination and appointment process, and I think that term limits would help that. But on this specific issue, I would just say, no one, or at least not me, I'm not trying to impute Ginni Thomas's actions to Justice Thomas, but the statute says if you or your spouse has an interest that could be substantially affected by the outcome of the proceeding, you're supposed to recuse. So does she have that interest? I think she probably does. Is she his spouse? Yes, she certainly is. Comes within the statute.
So what does this mean for the average Joe watching at home? Ilya Shapiro.
Pretty much nothing. I think this is a debate between and among elites, not so much inside the Beltway, although that's a heavy part of it, but in academia, the legal elite, and so forth. The average person who pays attention to the Supreme Court pays attention when various rulings come down, and we're about to enter the end of term heavy season where people are paying attention this term to cases involving abortion and guns and certain other things. I testified before Professor Roosevelt's commission on the Supreme Court, and certainly we can discuss whether reforms are necessary, term limits or otherwise, but that doesn't relate to recusal standards. For one thing, I'm not sure Congress can even require justices to recuse or impose various ethics obligations. There might be a separation of powers problem there. But moreover, again, just having a spouse who has an interest of the sort that she would like certain political outcomes to a conflict when that spouse has not even been involved, even with, say, a law firm that's been litigating the case, which in the past the standard has been that that's not enough to create a conflict, let alone being an active participant, an employee, or otherwise connected to a proceeding.
And Kermit Roosevelt, do you agree with that? What do you think is at stake for the average Joe at home watching?
Well, I think this connects to something that Ilya said before, which I absolutely do agree with, not in like a sarcastic way, which is that this vote, Justice Thomas's vote, was in line with his views about executive power. And I think that's something that the average person should understand about the Supreme Court, which is the votes of the justices are in some ways heavily overdetermined, in that the Supreme Court gets important legal issues where what matters is not so much which party wins or loses. That's not what people care about. What matters is the rule of law that the Supreme Court is going to announce for the country, what they're going to say the Constitution means, or what they're going to say the statute means, or whether this right exists, things like that. And the justices tend to have pretty strong views about those things, and views that definitely would overwhelm most sorts of conflicts of interest. So if you think about Justice Thomas on the one hand, or maybe Ruth Bader Ginsburg on the other hand, and you have an abortion case, and they've got an actual conflict of interest where they'll get, $500 if they vote one way rather than the other way. Would that affect their vote at all? Absolutely not. So like that kind of conflict of interest, I think really we don't need to worry about at the Supreme Court, but we do, because we think that Supreme Court justices should play by the same rules that other judges do, because we think the Supreme Court may be supreme, but it shouldn't be above the law.
And just finally, is there anything missing from mainstream discussion? Ilya Shapiro, would you like to go first?
I want to pick up on Kermit's point that the nomination and confirmation process is broken, because I don't think the process itself is broken or politicized. It's the product. It's the what we see with confirmation hearings and such is a symptom of a larger problem where what we have is divergent interpretive theories that now map onto partisan preference at a time when the parties are more ideologically sorted and polarized than they've been since at least the Civil War, if not ever. So there's no possibility of an uncontroversial nominee, and all the political actors are acting according to the incentives that they face, both the senators that are of the same party as the president and of the opposing senators and the nominee. So it's all kabuki theater. It's all a set political piece. And when you have an all-important Supreme Court and judiciary, of course, there are going to be these tremendous fights over each precious vacancy. And you're not going to fix that by changing elements of the process.
Well, I guess the one thing that I would point out is that the Supreme Court is different from other courts. and this is something that I sort of said before, but when we think about conflicts of interest or bias, we often think of a case where the issue is facts. Is this person guilty or not? And you wouldn't want the judge to have an opinion about that before hearing the evidence, right? That judge would be biased. With the Supreme Court, where the issue is law, we do expect the justices to have views about what the law is before they hear a particular case. And that's entirely proper, and they're appointed because they are learned in the law, and we expect them to have these views. So we should understand we're dealing with a slightly different kind of situation. But the takeaway from all of that for me is we should probably still apply the same rules to Supreme Court justices, just because we don't want them to be set apart from everyone else.
And Ilya, Shapiro, what's missing for you?
The flip side of what Kermit just said is that there are different recusal standards for the Supreme Court, because unlike lower court judges, if one of the justices recuses, nobody replaces him or her on that court. And so the bar has to be higher for a recusal, because we'd rather not have an 8-justice court or less if we can avoid it. There's a duty to sit that is stronger than for the lower courts.
Thank you both so much for your insight and your time today.
Thank you.
Thanks.
As debates continue surrounding the possible recusal of Supreme Court Justice Clarence Thomas, many law experts have weighed in, sparking larger questions about the court and the possible need for reform.
Thank you to experts Kermit Roosevelt, Ilya Shapiro, and Kimberly Robinson for their valuable input on the current and future state of the court.
Looking forward, we must consider all of the factors brought up today and remember that the decisions made by the court have real effects impacting the lives of real people.
And that wraps up this episode of On That Point. We'd like to thank our guests for joining us once more.
And as we say goodbye, make sure to follow us on Instagram and Twitter at On That Point and like us on Facebook. On behalf of our entire crew here at On That Point, I'm Stephannie Joseph.
And I'm Valerie Wencis. Thank you so much for watching, and we'll see you next time.